And that's the basis of arrest?
Courtrooms can prove to be the last line of defense against a corrupt police officer, and these judges demonstrated exactly how true accountability should look, starting off from the Harris County Criminal Court, where Judge Fleischer was presiding over a case where an officer had committed a racially biased traffic stop and was attempting to charge the driver without proper cause.
Initiated a traffic stop in Harris County, Texas, after observing the defendant exceed a speed limit of 45 miles per hour and make unsafe lane changes. The defendant did not have his driver's license, but told the officer his name and date of birth. While the officer was running the defendant's name, he observed the defendant exit his vehicle, and the officer told the defendant to get back inside the vehicle. And the defendant responded, "Do I have to?" The officer exited the vehicle and attempted to detain the defendant. The defendant tensed up and locked his arms.
Everything is conclusory. What has he done wrong? What?
It was the initial lane changes, unsafe lane changes, and the exceeding the speed limit that prompted the stop. And then at that point, he was just attempting to get
Stop.
An officer cannot legally pull someone over without reasonable, articulable suspicion that a crime is being committed, and that's exactly what the judge recognized. It was refreshing to see someone in authority stand up for the rights of citizens.
How exceeding speed limit? How fast was he going? I mean,
I spoke to the officer this morning, who told me that he was pacing the defendant at 54 miles per hour.
okay, in a what?
I'm sorry?
In a what? I mean, if it's on 610, he's fine, right? And then he's interference duties. What is he interfering with? What did he do wrong?
I think it was after the stop was initiated, the officer was running the plates, the defendant stepped out of his vehicle. The officer told him to get back in the vehicle. The defendant said, "Do I have to?" The officer told me that.
And that's the basis of arrest?
Judge Fleischer, who has a history of owning such corrupt police officers, once again stood tall and ensured that this officer was held accountable for this unlawful stop.
See how
Can I speak, please?
Don't. Are you losing?
No, sir.
Okay.
And Your Honor, furthermore, as he was attempting to detain him, he locked his arms and tensed up. So as he was attempting to detain him, following that incident of him telling him to get back in the vehicle. And it was that.
That's the basis for arrest.
It was just a temporary
Walking while
detention. He was just attempting to detain him while he was trying to
What's he
investigate.
doing wrong? What's he doing wrong?
65. Yeah.
No, I don't think so. I'm to find no probable cause. No, it's just, he gets out of the car, and then it just the virtue of fact him getting out in the car is interfering with the duties. Really?
Ultimately, the judge ruled that there was no probable cause, rendering the charges inadmissible as they were the result of an unlawful stop, and the entire case was dismissed in no time.
No. Just, when you get into, just be careful out there, man.
Yes, sir.
Life is hard as it is.
Yes, sir.
When you get into, you gotta be careful, man.
Yes, sir.
People are always out to get you. Be nice. It's not hard. Things will go well for you, Look, I got it. I'm with you, okay? Just hang tight with me for a second, okay? All right.
Although that case was dismissed, note how the next officer ultimately lost his qualified immunity entirely.
Officer Villarreal's car, I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneous.
Police officer Osvaldo Villarreal, who had shot and murdered an innocent civilian while he was on a call, was initially cleared by his department and continued on duty. However, a few years later, the family of the victim filed a lawsuit, and the officer was pulled into a pre-trial where his attorney made a desperate attempt to justify his actions.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He kept his hand in the front pocket of his hoodie sweatshirt. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that. He saw.
I looked at the dash cam from the two vehicles. His is the second vehicle that arrives, correct?
Correct.
So he didn't see all of it.
Well, he said that he saw
The victim, Benny Herrera, was unarmed and made no movements that could be perceived as threatening. Despite this, the officer's attorney shamelessly attempted to defend his actions.
He saw him skipping and running backwards in the street, all the while holding his hand in his pocket.
I have to say, what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Well, I don't recall at what point his camera was turned on, but he testified.
His camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see.
The judges came well prepared and refused to be swayed by the attorney's misleading arguments. What followed was a powerful and decisive statement from the bench.
Certainly was able to see Mr. Herrera in the street.
Oh, sure.
And he saw him with his hand in his front pocket. He saw him, and he knew he didn't start in the street, so he knew he must have come from somewhere. But he had his hand in the front pocket of his hoodie. He was acting strangely. I mean, he was skipping backwards in the street. He was running backwards in the street.
And now this is Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
According to the body cam, the officer couldn't handle the situation and resorted to using his weapon almost immediately. The judges agreed that such behavior demonstrated a clear lack of fitness for duty.
Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. As soon as he began to take his hand out of his pocket, he also moved quickly toward the front windshield, the front passenger window of Officer Villarreal's car.
Well, don't we have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities. He did it peaceably or he did it in reaction. So I'm just struggling with, in light of the standard that we have, here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket.
Well, not only should this cop's qualified immunity be abolished, but he must be criminally charged for murder. But the attorney continued to present her case on how qualified immunity protects him.
We should grant qualified immunity.
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know, with the benefit of hindsight, obviously, that was wrong.
Is it significant that Miali?
Miali
didn't fire? Chose not to fire? I mean, it seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. First of all, well, I'll answer your question directly, and then I'd like to go back to the standard. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket.
Well, this mistake was made only by Officer Villarreal, whereas another officer on the scene had acted calmly and refused to escalate.
Officer Villarreal didn't fire in the direction of anyone other than Mr. Herrera. Mr. Miali would have had to fire potentially in the direction of, in the videos you can see that there are other cars. So there are other people that could have been hit by a bullet from Officer Miali's gun.
Imagine ending an individual's life who was merely trying to catch a bus and claiming that it was an accident just because the officer was afraid of what could have happened.
The issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine, based on the facts as alleged by the plaintiff, And
Right.
they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension, they rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
And right now, we're
As
talking
long-
about your facts.
As long as,
Stick with theirs.
as long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I
in the
agree,
field.
but
What's even more concerning was that the dispatch had alerted Officer Villarreal that Herrera was not used to carrying weapons.
as a matter of law, the shooting here was legal.
Yes,
Those three
it
facts.
was objectively reasonable. Well, not just those facts. Officer Villarreal knew that that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
On
what
parole,
the
I
officer
don't
knew.
remember, on parole, they
On
said,
parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed, but that's not the same thing as saying he wasn't armed.
Shockingly, the police department had conducted an internal investigation and cleared the officer of any wrongdoing. This shows how messed up and bizarre these investigations are.
our opinion at Espinosa clearly somewhat favor denial of qualified immunity under these circumstances. I don't know if you're familiar with Espinosa, but it seems to be.
I'm sorry, Your Honor, I don't believe that I'm familiar with the Espinosa
Well,
decision.
in Espinosa, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The attorney claimed that the individual was killed because of suspicious behavior, and he acted weird because he was backing away from a dangerous armed cop.
Dramatic was the fact that they saw a bloody shirt, and some of the officers said it looked like fresh blood. Other officers said it looked like dried blood. And so whether or not there were exigent circumstances, whether it
But here, the domestic violence incident was over.
yes, and there,
So, I mean, how does that strengthen your case? I mean, if you're arguing that it was an ongoing
No.
domestic violence, so,
it wasn't an ongoing domestic violence incident, but they were investigating. He was a suspect in a domestic violence incident in which it was reported that he hit somebody on the head. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really
Counsel,
pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial, this is not summary judgment, it's a very limited thing. No one here has raised about the fact he didn't have a gun.
I understand, the trial court did.
And that's not what we're doing right now. Again, this is not trial court part two. This is a very limited inquiry, what we have to do here.
I understand, Your Honor.
After the defense's lengthy argument, one that overlooked several key facts, the prosecutor addressed the judges, explaining how the officer had acted out of fear and made a serious error in judgment.
Herrera, and I think you could say suspiciously, kept his hand in his pocket, and that the officers perceived a heavy object in that pocket. That's
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
well, and both officers said it looked like he had something heavy in his pocket.
Okay.
All right, and then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car.
Had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He responded to a command. He was given a command, he has a hand in his pocket, and he was giving a command to show his hands or take his hand out of his pocket. The officer was asked, "What was your intention?" "I wanted him to take his hand out of his pocket." He took one reasonable inference again is he took his hand out of his pocket in compliance with the command of the officer. When he took his hand out of his pocket, he had nothing in his hand. Another reasonable inference is that the officer could see that he had nothing in his hand before he fired his shots.
When the defense argued that the officer's actions were merely a mistake protected under qualified immunity, the prosecutor had a sharp and compelling response ready.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Under our version, both hands were visible and he had nothing in his hands and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available, and that a warning that deadly force, jury can conclude that his decision not to shoot when he saw the hand come out of the pocket with nothing in it was a more appropriate decision.
The prosecutor firmly established that the incident was entirely Officer Villarreal's fault. Still, the defense attorney stepped forward once again, attempting to plead innocence on behalf of the officer.
The police officer will bring in their use of force expert, and Mr. Gallipo will bring in his use of force expert to talk about what should have happened. I mean, juries do make determinations
But
on
they're
it.
not making determinations on qualified immunity, and that's the only issue in this appeal, qualified immunity, and whether or not the actions of Officer Villarreal were objectively reasonable in light of all of the circumstances.
You said something that confused me. The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial, the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
It's my understanding that the application of qualified immunity is a question of law.
Well, it is a question of law on undisputed facts or facts taken in favor of the other side, but I've never understood it to be outside the province of the jury when it goes to trial. To say that the officer does not have qualified immunity.
The jury has to decide.
The attorney wasn't making any sense at all, and watch how the judge even saw the insane act the cop had committed.
Predicate facts.
I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all. And if the jury were to return a verdict against Officer Villarreal, I think that he would have the opportunity to file a motion for a judgment notwithstanding the verdict on qualified immunity.
We're just looking right now.
Soon after, the judges ruled that qualified immunity would not apply and ordered the case to proceed to trial.
Is that there is a disputed material fact relevant to the application of qualified immunity, then the case has to go back. The district court's decision has to be affirmed. I think that on the record before the court, the videotape evidence, the deposition testimony that we have shows that Mr. Herrera's actions, Officer Villarreal's actions are not in dispute. We know what happened. And it's just a question of whether or not a reasonable police officer, knowing the same things that Officer Villarreal knew, would have felt justified in firing.
This is a question that's off to one side for me. And again, if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, the California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives.
Soon after this incident, the case went to trial, and we hope that the family of Herrera gets the justice they deserve. Well, that brings us to the end of this video. Today, we saw cases where corrupt cops were humiliated in courtrooms and taken to task by these judges. If you enjoyed this video, then don't forget to check out these moments where a higher authority owned these thugs.
I can raise my voice, right? No, you can eat a dick.
I told you I did 9 years in the military.
Can you please
After I
walk
served you
away?
for 9 years, you fucking dick.